This is the Coal Board Environmental Review for Grant Projects webinar. This is the Department of Commerce, which is administratively attached to the Montana Coal Board. This is an opportunity to walk through the requirements of NEPA, Montana Environmental Policy Act, in relation to Montana Coal Board projects. These slides are available on our website in PDF format under the toolkit. So the Montana Environmental Policy Act is a procedural statute only. It provides a process by which agencies are informed about the potential consequences of, alternatives to, and public concerns about decisions that intend to make that might affect the human environment. Montana Environmental Policy Act, or NEPA, is a problem-solving tool. The first objective is full disclosure of all relevant facts, and the second objective is public participation. It is in the best interest of the board to know the potential environmental impacts of coal board projects during application and prior to award decisions. Enacted in 1971, the NEPA Act is a problem-solving tool, as mentioned. So NEPA is, as I mentioned, a problem-solving tool, and I'm not going to read this full quote, but what we want to highlight here is the information in bold. NEPA should encourage and foster economic development that is environmentally and socially sound. If you want to learn more about the NEPA Act, you can go to leg.mt.gov and look at the NEPA Act on the Montana website. So NEPA is applicable to coal board grants. There are a couple of reasons for that. So in NEPA, NEPA applies to state-sponsored projects. This includes a project or activity supported through a contract, grant, subsidy, loan, or other form of funding assistance from a state agency, either singly or in combination with one or more other state agencies. In the case of coal board, these are in a form of a grant. Also in NEPA, it defines agency, which means an office, position, commission, committee, board, department, council, division, bureau, section, or any other entity or instrumentality of the executive branch of state government. And in this case, we're referring to the board, coal board. So coal board grants are subject to NEPA. There are 3 levels of environmental review specified in NEPA. They are based on the significance of potential impacts. First is statutorily exempt or categorically excluded from NEPA review. The second is environmental assessment, or EA. And the third is environmental impact statement, or EIS. Further, the coal board has adopted categorical exclusions for projects for which it would not normally prepare an EA or an EIS in considering applications for projects. There are about 10 areas that they have adopted categorical exclusions, and this comes from the Administrative Rules 8.2.304. So these include administrative actions such as routine, clerical, or similar functions, including but not limited to administrative procurement, contracts for consulting services, or personnel actions, minor repairs, operations, and maintenance of existing equipment or facilities, investigation and enforcement, data collection activities, inspection of facilities, or enforcement of environmental standards, ministerial actions in which the agency exercises no discretion and rather acts upon a given state of facts in a prescribed manner, actions that are primarily social or economic in nature and that do not otherwise affect the human environment. Further, projects that will be partially funded by or for which the applicant must obtain a permit from a state agency or federal agency, which by reason of its funding or permitting function has primary responsibility to consider the environmental impacts of the project under NEPA or the National Environmental Policy Act. Activities which do not involve or lead directly to construction, such as planning, studies, scientific research and analysis, surveys, or engineering. Projects primarily involving the acquisition of capital equipment. Projects where the footprint of the proposed structures, pipelines, or other infrastructure would be substantially unchanged from existing conditions and there is no increase in the population served by the facility. Or in the cases of emergency repairs, reconstruction, restoration, retrofitting, or replacement of an existing facility that is in operation or construction when damaged, and the action occurs within the existing facility footprint and in a manner that substantially conforms to the pre-existing design, function, and location as the original, which may include upgrades to meet existing codes and standards, as well as upgrades warranted to address conditions that have changed since the original construction, and it has commenced within 6 months after the date of the emergency. So number 10 is really about very specific emergency situations. So as we mentioned, there are categorical exclusions that the Code Board has adopted in relation to NEPA. If the proposed project qualifies for an exclusion, the applicant should submit documentation that the environmental process, including public review process, is complete, and the applicant has formally approved its determination that the project qualifies for an exclusion. An exclusion may not be appropriate if there is significant public controversy existing over the project's potential effect on the quality of the human environment. The proposed project shows some potential for causing a significant effect on the quality of the human environment, or the project might possibly affect sensitive environmental or cultural resource areas or endangered or threatened species and their critical habitats. This determination is made at a public meeting, and there's documentation of that meeting in the application. If there's information available to the board that indicates that a proposed project may involve one of those situations, as mentioned previously, the board may, in its sole discretion, require an applicant to prepare an environmental assessment or an environmental impact statement as may be appropriate. So the second level, we've talked about the first level of environmental review, that is the categorical exclusions. Second level is environmental assessment. For those projects that are not statutorily exempted or categorically excluded, the first step is to complete an environmental checklist. The checklist provides the initial evaluation and determination of significance of impacts. There's a draft checklist plus the environmental review form, which are circulated for public review and comment as the draft environmental assessment, or draft EA. There are no specific requirements for public review, but it should match the complexity and seriousness of the environmental issues associated with the proposed action and the level of public interest in the action. The complexity of the project may affect the length of time the public has the opportunity to comment, but this is up to the applicant. After public review of the draft environmental assessment, the applicant must consider all substantive comments received and decide at a properly noticed public meeting which of the following applies. To accept the environmental assessment and environmental process has been sufficiently completed, that the environmental assessment did not adequately reflect all environmental issues and must be revised, or that an EIS or environmental impact statement is necessary. Typically, in Code Board projects, we see categorical exclusions, projects that are categorically excluded, or projects that pursue an environmental assessment. As of recently in past years, we have not yet seen a project for Code Board that leads to an environmental impact statement. As such, I'm going to talk about environmental impact statements very briefly and refer you to read further in slides and other information in NEPA if interested. So an environmental impact statement is required whenever an environmental assessment indicates that an EIS is necessary or a proposed action may significantly affect the quality of the human environment. It must be distributed to the governor, the Environmental Quality Council, state and federal agencies, and other interested persons. It has a minimum of 30 days for public comment on a draft environmental impact statement. There are a number of required contents of an environmental impact statement. Those can be found in NEPA, and you may want to contact DEQ or other federal state agencies or the Environmental Quality Council if interested, or refer directly to NEPA. You can refer back to the PDF slides on our website about the different contents required of an environmental impact statement. And they are following on these next two slides. So once there's a final environmental impact statement, after public review, the agency must summarize and respond to substantive comments received. A final decision on the action must take place at least 15 days after the final EIS is transmitted to the governor and the Environmental Quality Council. So we've discussed the three levels of an environmental review. When working on a project, there may be changes to a project. At any time, if there are substantial changes to the project are proposed after the application but before the final drawdown of grant funding, the grantee must ensure that the environmental review, whether that's a categorical exclusion, an environmental assessment, or an EIS, that it still adequately identifies impacts of the project as modified. The grantee must demonstrate the public process was followed in making a decision as to whether the changes require further environmental analysis. The best method to do this is to prepare a new environmental checklist focused only on the proposed changes and any changed circumstances. Also, to go through the public review process and document that, which might include a notice to the public, an agenda, and minutes documenting that a final a determination was made regarding what environmental review determination was made. So as such, many of the questions we receive and wanted to provide clarification on is what kind of documentation is required and expected from the board to ensure NEPA compliance in a COBORD grant application. The COBORD is looking, and staff are looking for documentation that the public had the opportunity to review and comment on the categorical exclusion, a draft EA or EIS. This could include a copy of a published or posted notice of the availability of document for review and how to obtain a copy. This could be in the newspaper, this could be online, this could be in many formats. It makes sense for the applicant. This could also be letters, emails, or summary of comments received, if applicable. Second thing that the board and staff are looking at are documentation that the public meeting was properly noticed. This could include a copy of a published or posted notice of public meeting at which the document will be discussed and an environmental decision made. The third area is documentation that the final decision on the environmental document was made at a properly noticed public meeting. This could include a copy of published or posted meeting agenda and a copy of meeting minutes documenting what the action taken was, whether it was to accept a categorical exclusion or that an environmental assessment was adequate and no EIS necessary. And it also, usually includes approving the submission of a grant application if it's during time of application. In terms of time frame and how to notice to the public, this is up to the local government or applicant to decide to ensure that they are meeting state, tribal, or local requirements for advertising timeframes. And the action can be in the form of a vote, an action, or a determination made at the local governing body meeting. But again, the board and staff are looking for documentation that determination was made at a properly noticed meeting, which typically are minutes from a meeting. So in summary, NEPA is required. NEPA compliance is required for COBORD grant applications. The three levels are the environmental review. Categorical exclusion, environmental assessment, and EIS. Documentation required for a categorical exclusion, environmental assessment, and EIS is always the environmental review form. If the applicant is pursuing an environmental assessment, then additionally an environmental checklist is required. There's a unique EIS process, and that's a more complete study as briefly described in this PowerPoint. Encourage you to reach out to DEQ or Environmental Quality Council or look into NEPA specifically for more information on an EIS. Other considerations when looking at NEPA compliance and documentation for a COBORD grant application. The COBORD may categorically exclude projects from NEPA requirements which apply to COBORD regulations and will not normally prepare either an environmental assessment or an environmental impact statement in considering applications for grants to finance projects. This determination is not something that the Department of Commerce determines. Therefore, Commerce staff will not comment on that in the staff report. And instead, the comments on staff report include comments that reflect the completion of the process, not the determination made. So under state law, individuals generally have 30 days from the date of a decision on the environmental document to legally challenge the decision. After that, the decision really cannot be challenged unless the individual can show that the public had no knowledge. If the grant applicant follows the procedural process that's described and it documents that the public had knowledge and opportunity to object, then the NEPA review process is complete. After the grant is awarded, the applicant moves forward with other startup conditions and gets the project completed. If one recommendation and one suggestion we have for COBORD applicants to consider is if your application is applying for some kind of construction project, which typically goes towards an environmental assessment, we recommend that doing this up front particularly if Coal Board is one of the first funding sources involved in the project, because typically the project has other sources of funding that might include Treasure State Endowment Program, Community Development Block Grant, those are funding sources from Department of Commerce, or RD, Rural Development, or other federal state agencies that may require similar or sometimes more restrictive environmental review processes for construction. This process and beginning this at the beginning may help you in the long run. If you have questions about Montana Coal Board or the Coal Board review process, please contact the Montana Coal Board staff at the Community Development Division at the Montana Department of Commerce. Our website is comdev.mt.gov. You can also contact us at 406-841-2770 or doccdd@mt.gov. Thank you.